Good afternoon, ladies and gentlemen. Welcome to BW Legal World Saturday Solutions segment where we speak with experts on hot legal topics and latest legal developments. And today we are discussing contract drafting and negotiation tips for lawyers, entrepreneurs, and business professionals. The idea behind this webinar is to further delve into contract drafting and pre drafting negotiations to ensure your commercial agreements are set on a sound footing. To make this happen, we are once again joined by our panelists from last week, starting with Ms. Akanksha Joshi, partner in the Energy and Infrastructure, Hospitality, Corporate and Commercial, Private Equity and Real Estate practices of ERP. We have with us Mr. Lalit Kumar, partner Jyoti Sagar Associates, a corporate M&A and private equity lawyer with over 20 years of experience. He has substantial transactional experience in advising both Indian and foreign entities in several complicated domestic and international corporate commercial transactions, including private and public M&A, private equity, joint ventures, and complex corporate restructuring. We also have with us Mr. L. Patri Narayanan, Executive Partner, Lakshmi Kumaran and Sridharan, who has a rich experience in cross-border investment and tax laws. He has been advising several companies on a variety of issues such as consortiums and joint ventures, valuations, secondment, royalties and licensing arrangements, contract manufacturing scenarios, software as a service offering, and outsourcing. Thank you, experts, for joining us for this discussion. And I am Asha Mori, Managing Editor of BW Legal World, who has the pleasure and honor of moderating this session for you. So, without further ado, I'd like to open the floor to our speakers and ask them the many questions we received from our audiences last week. I would like to jump directly and open the floor to Badri first. So Badri, thank you for joining us once again. And last week, all the panelists, including you, gave us some really interesting points on how you go about drafting. However, we still have questions from the audience, which are about knowing your mindset about, this various sections that you draft. And the particular question goes like this. Could you please run us through the different sections of a contract and the brief thought process that goes behind each section? I'm sure we can't run into each section, but what are the operative clauses and what are your thoughts behind them?
I think, like I said, it was a good question. Okay, and every lawyer typically will have different types of sections which will be there in a contract. So, typically, for example, if you take a contract, okay, so there will be some formal sections, which is like the title, the parties, definition and interpretation clause, which I call a little bit formal way. Then you have, for example, what I call as the deal terms, which is the actual contract. So that will be the operative clauses, as I say. Okay, this will be the condition, the consideration, and the scope of the contract. So that's the second part of what you have. Then you have what I call as the operational and core issues which are there, which is the reps and warranties, governance, conditions, uh, uh, event of default, things like this. And then we have the exit clauses, which is like the termination clauses, liquidated damages, event of breach, what happens, the consequences of breach. Then finally, you have some boilerplate with respect to severability, entire contract, and things of that nature. So typically, that's how you kind of look at a contract, and each of the thought process for each of these requires kind of slightly different things. Okay, first and foremost, title and parties. We've all seen that we have negotiated a contract and you put the wrong party in. Okay, so one of the key things I keep asking people is that, bhai, have you confirmed that this is the correct party? I think many times we just take one entity, especially when there are group entities, where you take up one entity and then you think that's the contract because it ends up being with someone else. Okay, and so getting the party right, easiest thing, but many contracts we make mistakes with respect to that. I'm going to talk a little bit about the definition clause in a minute, but definition interpretation, parties and title are fairly straightforward when it comes to this. And then you have the operative clause, and I think that's where you kind of do it. You either there the thought process is to kind of understand what the parties commercially are wanting to happen. So that typically comes out of a term sheet or a discussion with the client. He'll typically say, "This is what I want. I want a license. I want a sale. I want to purchase an asset or a transaction," and so on and so forth. and then what are the conditions that they have agreed commercially with respect to that, and kind of capture that. So I think that's there. It's important to kind of be able to capture that accurately, either in the form of an annexure, or in the form of or a clause which is going to capture what the contract. That's one clause which the parties will understand looking at it. Okay, this is what it is. So that's the second aspect which you have. Thought process is to kind of be able to capture it as quickly as possible. But the real third part, which is the covenants and reps and warranties, are where I spend a lot of my time talking to clients, okay, especially foreign clients, because you want to kind of understand what are the risks involved with the business or the transaction or the issue, and what can go wrong, and what are the things that you need to be representing. You get representation on the other side for the past, and what are the things that you want to impose on them for the future. I think typically you'll find that this is one area where some of the less commercially oriented or people who have not done transactional contracts don't spend a lot of time thinking through. So they think because contracts are all entered when it is happy times, okay, and it is litigated in times when it's not so happy, okay. So then the lawyer is always asked, why didn't you think of this? Why didn't you think of that? So I think the key thing is to kind of think a little bit about the reps and warranties. So what do you want that fellow to represent, okay? And how do you kind of make sure that, and you typically ask for representation that which are questions of fact, which even also he will not be able to verify and you will not be able to verify. So that's the art is in that, and to kind of think through that. And then similarly in covenants, what do you want to impose so that he can continue to do his business, but your rights are protected. So that's the area where I spend a lot of my time thinking and talking to, especially foreign clients, and they kind of understand that a little bit more. And then consequences of default. Typically, you want to understand material clauses, breach, what constitutes, what will be the events of default, and then you kind of work your way down. In case this happens, what are the remedies you want? You want liquidated damages, you want injunction, you want this thing. And then another area which comes up is term and termination. You always want to have, whether you want to have a choice of termination, if you want to terminate, how to terminate. So you kind of think a little bit and talk to the client with respect to that. Many times clients will not have a clear view of term and termination. Okay, they'll have some idea, but typically, so that's one area where again you have to flesh out a little bit and understand what it is. Sometimes they'll take unreasonable positions also with termination. This agreement can never be terminated, it will be in perpetuity. Okay, life never works like that. So kind of explaining to them the pros and cons of it, what is it and how it is. Especially if you're doing employment contracts, very, very different to other contracts. You cannot say that you'll be there. You don't want to have that person be classified as a bonded labor to you. So there are certain things that you have to be careful with respect to that. And I think finally, just which are the things that you need to take into account. So that's again something which you kind of look at and do. So those are the things that we kind of focus on when it comes to this.
Thank you so much, Patri. Just also one question that comes to mind: how important is preamble or the recitals to these contracts? Do you, are those just redundant boilerplate, sentences, clauses that just feature in a contract, or are they really important when you sit through them as well?
I think definition clauses, I have some views. For example, so I keep getting asked this question by our associates, whether I should put this in the contract or I should put it in right up front in the definition clause. So one of the things that we do always is that even if you put it in the body of the contract, you have a reference there, because you want to be able to quickly refer and find out. You shouldn't have to remember where the definitions are. So at one good way of doing it is that everything should be, any case, referenced back to the main clause. The rule that I kind of follow is that if a definition is only for a particular clause or only for a sub or a section of the contract, then it is better to put the definition there and have a reference to it in the listing, because when you're reading it there and then, you're able to get the definition there itself. So I prefer to kind of put the definition in the clause or in the section where the definition, if it's only going to be there. Where definitions are going to be there in multiple places, I prefer to put it right up front or in the first place, or whichever I feel is the most appropriate place. Okay. And then you kind of refer it back and forth from there. I think that's something which I think is important, and it's easy way of doing it. Like I said, always good to refer it back to the original place where it is, so that you have it. So the purpose is to kind of make it readable, and person should be able to do that.
Yeah, I think that's a
Um,
fair point that you have it in one place. And I would like to quickly jump to another question to you, Badri. In the wake of the new, judgment on emergency arbitration, there's also a question which came last week. So the question goes, should the clause for emergency arbitration always be explicitly stated, or is it implied in a general arbitration clause? Now, in the light of the new judgment, what are your thoughts?
I think one. So I'll just. This has been a very very interesting judgment, right? So what has come out from Supreme Court, basically upholding the emergency arbitrators interim relief. I think
In
few things
favor of
I'll just.
Apple.
Yeah, few things I'll just say so that everybody understands what is it. Okay, so emergency arbitrator and emergency relief are two separate things. So we have to be a little bit careful with respect to what we are trying to say. Okay, so emergency relief or interim relief, as many times we say, is one aspect of this thing. Getting that relief from an emergency arbitrator is the second aspect. So you must have these two separated. Okay. So sometimes we think that emergency arbitrator is associated, of course, is associated with emergency relief, but it's not that he's the only person who can give it. So this is something which has come out, and there is a particular reason why in this matter it came out that way. Okay. Um, so I don't want to get into the facts of this matter, not because I think I've given some advice at some part of art, so I don't want to kind of be
Sure.
saying things. But I'll give a hypothetical example, and I'll say how this kind of works. Let us say that there's a company A, it has entered into a contract with company B, which is part of a conglomerate, and there are other companies C or related parties C, and you enter into an agreement with between A and B, and you want B to undertake certain things, okay, and then to kind of refrain from doing certain things. And in the business of B and businesses C or D who are not parties to the contract are also, let us say, interlinked in some way. So the real question comes is that if B reneges, okay, it's this thing by not itself but by somebody else in the group company, how do you get relief? Okay. So here you have two three options in a general setup, and how typically you kind of do that is when you have a normal arbitration clause. The two ways in which you can get interim relief, I'm not talking about arbitrator, interim relief is one, you go to court on a section 9 and get interim relief, or you go to your arbitral tribunal, okay, and they will give you interim reliefs. So that's typically how most of us think of this in a particular way. In this case, if let's say A, B, C, where C is doing something which is going to have an impact on B, which is going to have an impact on this thing, both Section 9 and the arbitral tribunal being set up, because arbitral tribunal takes time to set up. So you will have a tribunal, and typically arbitral tribunal doesn't give interim relief automatically because they know that over a period of a year or two, they have to decide the matter. So they're always wanting to know more before they're going to give any relief in these cases. So it takes longer for, especially in complex contracts where one party is there but some other party is doing something related to it, and you want to kind of, you're not able to get an immediate relief because you're not able to run to an Indian court or a tribunal. So in this kind of a situation, there are suboptimal solutions available with respect to this. So this is where the emergency arbitrator comes in, who basically his only job and his to be able to come in. It's not appointed by you, it's appointed by, let's say, an institution. So that's important, to like what Tariq was saying last week. Important to have your arbitration clauses wide enough and to be able to go under an institution, because when they select an institution, all the rules of the institution also become part of the contract. And then from there you can kind of go and pick some of the aspects. So the institution basically allows one of the parties to be able to write to it, and it appoints an emergency arbitrator, and then the emergency arbitrator in turn passes interim relief and nothing more than that, and his job is finished. And because he has only one role, which is to pass the interim orders, that's a very effective way of getting relief. So that's typically how the whole thing plays out. So you really want to use it in this manner. So like I said, emergency arbitrator and emergency relief are two separate things that you must keep in mind. And emergency arbitrator provisions, okay, again are important. So what you asked, that do I need to have an explicit emergency arbitrator clause or is a general arbitration clause? So first and foremost, emergency arbitrator is not implied in any arbitration clause. Okay, so one way in which you do it is by referring to an institution which has emergency arbitration rules, which is, I think, the most efficient way of doing it. It also ensures that they can quickly. So emergency arbitrator literally can be appointed overnight by the institution. You make written submissions to it. He may not even ask you for an oral hearing. He will just, based on the submissions, pass an order basically immediately, so that the parties are not worse off from that. And the beauty of it is that you get really quick relief on these matters. Okay, so the key thing is to kind of have an arbitration clause. So if you're going for ad hoc arbitration, which is what most of the arbitration tends to be here, you need to have explicit this thing, because what you are effectively asking for is an arbitral tribunal which is able to give interim and final relief. Okay, that's what your general arbitration clause says. Emergency arbitrator is a completely different tribunal or a different arbitrator, and for that you need to explicitly agree to, or like I said, you kind of get it through institution. So that kind of answer. So long story short, you need to have somebody who is appointed. You need to have explicitly emergency arbitrator clause in the contract. So a very long answer to a very short question of yours.
So thank you so much, Patri. That quite well explains what's the process and how one can go the best way forward when appointing an arbitrator. Akansha, quickly moving to you, and sorry for making this a little bit of a rapid fire, but we want to take up as many questions as we received last week. Now, the next question for you is: if the contract says contract may be terminated in case of any illegality, would any kind of breach lead to early termination? Would this give right to the non-breaching party an absolute right to terminate the contract?
So, I mean, as we spoke last week, the entire idea of interpreting a contract is to read it within its entire context. So, for instance, a company which is supposed to comply with maybe hundreds and hundreds of laws would be non-compliant with some small issue or the other, right? So there's one filing which has not been made, which is not even relevant to the contract that we have at hand. So, I mean, I'm a little, I guess, hesitant to interpret this particular clause without the context that there is. But if I were to look at it in its entirety, I would look at it as an illegality which would be in the context of that contract. However, the way it is drafted, there is an uncertainty as to whether this, means that the other party can't be, non-compliant with anything. But I don't think that's a reasonable sort of interpretation. And we would have to look at the contract in that context. And then
and
see
this is the kind of drafting that you would kind of avoid, like leaving it open.
Yeah, I mean, I would look at that, and I mean, if I know we're going to talk about negotiations, but my question would be why? What are you trying to cover? Questioning the other party is honestly one of the best ways to get to where we need to be. So if this just came to me, I would just want to understand what is it that we're trying to cover. But if, let's say, this came to me after it was signed, I would want to see it within the context of the entire contract and see what the parties intend. So yes, in isolation, it's a bit difficult to say. But I don't believe that the parties would leave it open for any small infraction which is unrelated to the contract to lead to a termination event.
Thanks, Tansha. And there's a long question on governing law, but I'll keep it short and jump to the crux of it, which is how do you get two parties, two cross-border parties, to agree on a governing law, to mutually agree to that? So, any tips on that?
So when you have an Indian party which is contracting with a foreign party, you always have this question as to, okay, we want to apply Indian law, we want Indian courts, while the other parties are a bit wary about, applying that. So what generally happens is, and what really works is if you say that you want the contract to be read in accordance with English law, and that is something that even common law countries common law countries are the ones where they've used English law as a base and have evolved from there, as compared to civil law countries which are continental Europe, China, etc., where this is not common. So, but there is a familiarity with English law because of the fact that they were our colonial masters and colonial masters, so many people across the world. And I've seen that has been generally something that people are willing to use as a neutral law. for interpretation, and which has a lot of the concepts that we are aware of in Indian law and across international law. So that is something that I would suggest. And the question also comes in as to whether a foreign governing law is valid. Is that choice of law valid? And you're talking about Indian courts. Not saying that this question is not fraught with doubts, but at the same time, if there is an Indian party and a foreign party, courts do uphold laws other than Indian law. The question would be whether two Indian parties can agree to a foreign law, and that is really where there is a lot of, I would say, I think disagreement between our lawyer community itself. But in my view, two Indian parties cannot contract out of Indian law.
All right, thank you, Kanksha. And force majeure has been such a highlight in the pandemic. And there's a question attached to that. Do damages under loss of profit need to be looked over again, especially with the new force majeure interpretation in contracts?
So force majeure, I think the context is a little different, right? So the way I would look at it as force majeure is if there was no force majeure clause in the contract would stand frustrated or void, right? Because basically, if a covenant or the basis of the contract becomes impossible to do because of certain supervening circumstances, then that would lead to a frustration of the contract. In order to ensure that a temporary event does not lead to a frustration and that the parties know how they want to take on a risk, which would be defined as a force majeure, you introduce a force majeure clause and you have to comply with its definitions, etc. Force majeure is a pure creature of contract in that sense. So if you look at most contracts, you will not really find an apportionment of expenses. The only consequence of a force majeure clause usually is that the obligations to perform are suspended. That you are not going to be in breach if you don't perform this particular obligation of yours, which is affected by the force majeure. It's only in infrastructure contracts that you see, where you're looking at apportionment of expenses, where because of a certain force majeure event, the government agrees to pay a certain amount of money to the private party. So I'm not sure whether you can say that it should be considered for damages, because damages really, if you look at Section 73 of the Indian Contract Act, it says which arose in the ordinary or the normal course. And force majeure is looking at a situation which is not in the normal course. So if you're looking at apportionment of expenses or damages, etc., we need to write it down in the contract. It is not Section 73 or any other contract act which is going to give you relief.
All right, thank you, Kamsha. And some very short questions there. I'll group them together. For purpose of interpretation, can you include reference to certain legal dictionary in the contract? Is that a sound practice? And do contracts signed over emails, have the same sanctity?
So you can, of course, refer to a particular definition of, let's say, you could say Black's dictionary or the law lexicon, etc. But I would still not prefer it. There's nothing stopping you from doing it because many times those definitions are more generic in nature, and you may need something more specific for that particular transaction that you're looking at. But there's nothing that would disallow it, and if you are keen on doing that, then I would just say that please mention the addition, because all of these dictionaries, etc., are updated based on the evolution of the law and the meanwhile. So if you want to do it, then please say Black's Law edition 14th, Black's Law 14th edition. But it's not something I would recommend as a practice. And your second question was email contracts, whether they are valid. Yes, and during this pandemic, it's the time where we've been signing a lot of documents across various jurisdictions completely online, where what we're doing is we either electronically signing documents or sending scanned signature papers, and those do form valid contracts. So of course, we do follow it up in good order with hard copies which are physically signed with the stamp paper, etc. But given the vagaries of the times that we're in, yes, that is a valid way that you can sign up to a contract.
Would you always follow it up with hard copies, or could those be done away with in light of climate change?
No, so maybe I'm a bit radical. The reason I would suggest that you use hard copies is because we have stamp duty laws in India. So which is why we need to have a physical stamp paper attached to it. So then I'm like, might as well have the physical copy. But according to me, even and not according to me, sorry, according to the law, even an exchange of letters can lead
Yeah.
to the formation of a contract. So if you're speaking from a technical perspective, yes, you don't really require any physical document given the situation of the law, but I mean, it's just for the sake of good order and to have, your stamp paper really cover a certain document.
Thank you. Thank you so much, Akansha. And now I would like to move to our next set of questions that are for Mr. Lalit Kumar. Mr. Kumar, could we have you on video, please?
Sure.
Good to see you, Mr. Kumar. And there's a question which has just arrived from the audiences, which I'd like to take up first. Do we need to follow any specific sequence while drafting conditions in a contract?
I would say yes, because a contract is a set of provisions and it has to follow a certain sequence. A badly drafted or a jumbled up contract, I mean, you will be lost for finding the provisions. So therefore, I would say yes, do not jumble up the contract. There is a certain sequence to it. Some people prefer, for example, to put the definition section right at the top. Some would like to put it as an annexure. Whichever way you would want to do it, that's fine. I prefer putting it at the beginning than at the end, but you must follow the sequence. Say, for example, in a typical services contract, you would first write the parties, the definition, and what is the main subject matter of the contract, the services in question, then the consideration part of it, and then other incidental part. And then towards the end, you have miscellaneous clauses, and before that, termination clauses. So yes, I would follow a certain sequence, and it makes it more user and reader friendly, and it will help everyone in the event should anything go wrong with that contract.
Thank you, Mr. Kumar. And I think speaking of sequence, there's a question that comes from a student, and it would make sense to take it up, in this context. For someone who is barely halfway through law school and wishes to learn drafting of contracts, how would you suggest them to begin? And if possible, could you shed some light on your experience while drafting your first contract?
Okay, this is an interesting question. My suggestion would be that first, depending upon what your subject matter of interest is in your law college and the level of education that you have already, gained, you pick up a topic which best suits you and interests you, because by that you will be able to even like to read that contract. Say, for example, you like an employment contract or a services contract or a joint venture. Pick anyone and first see templates, right, or executed contracts and read through them. I would also request and suggest that don't take up a very long and a complex contract, because what happens is that the interest will be lost and you will be very discouraged to read further or understand it further, because the language could be very, very complex. Pick up a simple contract like a services contract and see for yourself that how it is laid out, what are the provisions. That is one. Second is that do test it with the legal knowledge that you have acquired. Say, for example, all of us study Indian contract at very, very early in the first level or in the first year itself. So do test it for yourself. Like, for example, there is this section 10 which says what are the essentials of the contract. There has to be a consideration, free consent, and all of those. Test it for yourself. Look for the provisions in the contract act and see for yourself that those provisions do exist there. So what that will do, that will help you understand that the contracts are actually getting derived from the law, and by that you will also maybe able to practically see the law that you are studying at law college. So, and of course, keep reading more and more, because there is no end to it. And as you grow in your profession and in your studies, start picking up complex contracts. And then also sometimes start from scratch, because it's like reading something is always looks simpler, but when you sit with it, like it's you read about swimming and then go for swimming, they're two different things. So therefore, pick up a contract and go through it, write it for yourself. You will realize how much you would need to still learn to write a good contract. and follow good templates. And I think this is what a beginner must do, and I'm sure it will be paying off. Now, you asked me, Ashima, what's my first contract? I don't distinctly remember, but what I remember is I was given a contract which was an escrow account. An escrow account where two parties wanted to put their money and shares separately. And then my senior told me that, why don't you take a shot at the escrow account? And he gave me few templates. So it was a simple 3-page contract, but back then, several years ago, I found it difficult, and I drafted what I could, but my senior did guide me. But yes, and the journey is still on, because you keep getting very complex contracts. But yeah, my first contract was escrow agreement, and I think I learned even a bit there as well.
I think it takes about some learning to stay above water. Like you said, if you're going to theoretically learn swimming, it's not going to help. So it always is better to, get drafting. And I'm sure your tips would come in handy to all our students and other lawyers, Mr. Kumar. Another technical question that has come in is, it's a long question, so I'll pick it up. When dealing with service agreements for foreign government bodies in countries like Singapore, they insist on indemnity obligations on the service providers, including for indirect damages sometimes. In cases of which defaults, if any, can we accept indirect damages as removal of the indirect damages in entirety, if often not an option?
Okay, I think Akanksha did touch upon this when you asked her about cross-border contracts and the governing law. See, it lots depend on the bargaining part. Like the situation, Ashima, you are describing. So there is a party in Singapore, and there's the other contracting party. I'm assuming the service provider is an Indian party.
Yeah.
Now, generally, when you are pitching for services contract and you are looking for getting that mandate or that contract awarded to you, I think you will be not at a very strong bargaining position to change the governing law. Assuming you are able to change the governing law to an Indian law, your first argument would be that as far as Indian governing law, Indian Contract Act is concerned, Section 73 doesn't allow any remote and indirect damages or indirect losses. So you could argue that out, that this contract is as per the laws of India, and therefore, why do you want to contract outside the law and say that even indirect damages and indirect losses can be awarded? So you should argue like that. However, that may not be the case all the time, because if it is governed by, say, the laws of Singapore, and the other side tells you that, but in our law, even remote and indirect losses are enforceable, you will be in a spot. Then it boils down really to the bargaining position, that who needs that contract more, and you will have to eventually sometimes agree to things which are even not which are against your wishes. However, one point I will also like to highlight about indemnities. See, both under the Indian contract, and I'm assuming even the laws in Singapore, under Section 124 of the Indian Contract Act, for indemnities, you can also ask for indirect losses. So therefore, if it is a contract or a provision relating to indemnity, maybe the counter argument against you would be that we are seeking indemnity, and even Section 124 allows indirect losses and indirect claims, unlike damages. So your position will further be compromised. So my answer to this would be that, look, if you try or negotiate, try hard, or put up your bargaining position, but if things are not working out, then do agree, but do agree to also look for a cap. You please say that, look, remote damages or indirect damages or indirect indemnity could be very, very uncertain. Please don't put a service provider to so much of uncertainty. Why don't you cap it at least to the amount of the service fee that you have paid? So try those things and then see where you land up in your negotiation.
Thank you so much, Mr. Kumar. I think that beautifully helps us segue into our negotiation tips for lawyers. So I'll start there. Bargaining powers, that's what you mentioned. And I think it would be best if you address the question on what are the principles of bargaining, and what thought process you have while dealing with this.
Yeah, it's a good one, good question, and a very difficult thing also. See, in any contract or in any dealings with people, your force or your strength depends upon how much you can bargain with that person. Say, for example, take a joint venture. In a 50-50 joint venture transaction, I think they will equally have bargaining power. I will always have a very difficult job to convince that what I am saying must be agreed and what you are saying may not be agreed. Similarly, put it up in a different situation like of a startup which is in needs of funds. Now, and I am the counsel or I am drafting a contract for the startup. I think I will have a very, very low bargaining power because I am in need of funds. The investor or the lender, whoever I'm looking for funds, would have their ways. They will say, we want this clause and this is standard. So I may have to agree on that. Or imagine a startup which is a unicorn, which is about to become a unicorn, or it is the investor which is looking to invest, not the startup at that moment and that stage of its operations. I can put my foot down. I can say that, look, I'm not going to agree. You want to invest, great. If you don't want to invest, I won't say that, but I would mean that. So the person would understand. So therefore, a lot depends upon the facts and the circumstances that you are in. There is no, one rule and which I can tell that this is how you can bargain. But I would always say that when you are negotiating, do not even let people feel that, look, you are ready to give up. Sometimes it's a part of the strategy also that you give up a point, but you don't give it up too soon. Hold on your point, bargain it, negotiate it, keep your your foot there and stand there and give it the point, and eventually maybe you get some other points. And you should not be a very easy and a very mild and a soft negotiator. You must put and be assertive and put your point forward. But yes, it all depends upon what position you are in when you are writing a contract, how much you can bargain in that contract.
I believe the lawyers would already know that where they stand in that sort of, an arrangement. And just to put this into perspective for our audiences, Mr. Kumar, how long, a negotiation goes on, and typically, like, what are the number of days that you would say go into negotiating some of these contracts?
See, typically, the kind of work that I do, transactional law, I think it could go for even 1 week to 10 days at a stretch, sometimes with a break. So these are hard negotiation, which means before pandemic, they were in-person boardroom negotiations. Now they are online, but the number of days and efforts hasn't changed. So typically 1 week to 10 days, it goes on and not at a stretch all the time. So you would go along for 2-3 days, negotiate hard, come back. There were points of disagreement. People will take a break, go back and then talk to their respective principals and clients and see where we can budge. Then again, a round starts. So 5 to 6 to 7, days go in this, but even otherwise, there are different calls and discussions keep on going. But hardcore negotiations, in my experience, you start landing up at good points and at points of consensus after 5th, 6th or 7th, or definitely around 8-9 days, it gets over. And they are very stressful at times, I must say, but the end is generally good.
So is there a pattern to it? Like you start out absolutely, not agreeing to some of the things, and then gradually mellow down, and then everyone starts to agree with each other. Is that how it goes, or do you see that people come on board willing to, see each other's point and negotiating the way forward?
I think, in my view, the negotiation must follow the strategy of win-win. It never happens. I have never seen a deal closed by bullying anyone. At least that has never been my experience. Some people try to posture a position and themselves and say that they are not hard negotiator. They will not agree to anything. They'll come. They'll be arrogant, rude. All that is part and parcel of it. But they realize sooner or later that the other side will also not going to give up the points so easily. So a consensus must come, and win-win situation must come. If the contract needs to get, both parties should feel that they have got something out of it. But generally what happens is that in the beginning, because sometimes in the beginning it's the two sets of lawyers who will do the negotiations, and the clients and the principals come little later, because they let the lawyers decide and then only discuss the high level points with their principals. I would say when the lawyers are negotiating, the negotiations are more hard, because people don't tend to give up their point. So those parked issues, as we say, they go to the principals and the clients, and they are milder than the lawyers. So in my experience, initially things are a little hard, but then they start settling down. People start getting points. They give up points, and then they are also told by their principals, we need to close. We can't keep negotiating and lose time. So eventually it gets smoothened and gets easier. So initial 2-3 days are more difficult in my view than the
Thank
later part.
Thank you, Mr. Kumar. That sets a picture in mind. And I'd like to bring in Mr. Narayanan, for my next question on, what are the considerations that you have in mind while negotiating, and do culture, emotions form a part of it? Where the party is from, the country, the kind of laws there are. What are the various aspects, soft and hard points that you have in mind?
I think, like I said, negotiation is more an art than a science, and I think understanding things which are beyond that is as important as what is the term. And of course, I think commercials are one level. I think like culture and not being able to understand other side sometimes has a huge impact on negotiation. So give you some examples. For example, the Japanese have a particular way of negotiating. Okay, so they're extremely detail oriented. They want everything to be certain, and they want to be able to know what's going to happen over the next 30 years. Okay, and everything is thought out. So if you've said something 3 months, 6 months ago, and you say something different today, they will immediately take out their notes and say 6 months ago you said this, but today you're saying this. And then as Indian lawyers, we're very creative and find a solution of being able to match both of them and why you're and justify what is it. But typically they view in a particular way, extremely risk averse. And so, for example, there is this thing. And also that also means that it takes longer for them to take decisions and come back. While if you look at Indians, promoters and Indian, they tend to be a lot more quick. So they are more execution mode. Their general feeling is contract will cover up most of the stuff that we need. It's not going to be relevant for us on a day-to-day basis. When a litigation happens, we'll open that from the vault and look at it. So I think they have a little slightly different. So there's a lot more focus on getting it done and then moving on and actually doing the work. But then, so when you have these two cultures which are quite different from each other, you see a lot of clashes and a lot of misunderstanding in the negotiation. So you say something, other side is taking say a month to come back. So you think in the meantime they're not interested. You take a certain position. Okay. So I think right up front, just being able to tell your principal what the other person is likely to think and how it is, and that communication makes it easier. Okay. I think that's one of the things that you have to be careful about. Other sometimes, especially with French clients or German clients or Eastern European clients, there is a language barrier at times. So, for example, especially if they're French and they're not from Paris or who are not multinational-ish. Okay, so they have a lot of issues with, for example, being able to understand some of the words that we use, and it's misinterpreted a little bit at times. So when you're negotiating, you may be thinking you're doing a great job. Other fellow is understanding it differently. So again, being able to communicate during negotiation, these mini negotiations and mini communications that happen between counsels is extremely important in making sure that the negotiations happen, because sometimes the principals may not always be talking, and the principals may be listening to other side's lawyer may misunderstand what is going on. So to have that comfort and be able to make sure that you're communicating is extremely important when it comes to negotiation. So again, culture, emotions. Sometimes when Indians especially are very sentimental and emotional about certain things. So for example, you build something and then you're selling it. It's almost like, you're giving up something. People take it very, very personally. While if you take, for example, Americans, they're a lot more detached about certain things. A transaction is a transaction. So sometimes again, you have this issue where you want to have access for a longer period of time on certain. So there are clauses not necessarily which are main clauses, but what I call have sentimental value, which tends to have an impact on how you negotiate. So also a lot of it is about telling your client to let go and not to misunderstand the other side, because they're coming from that perspective, from your own experience. Another thing is to kind of be able to communicate back to the side that this is important for us. And sometimes they say, okay, if it's important, keep it, because it's not sentimental for him, right? So being able to kind of manage some of those dynamics is extremely important in negotiations.
Like you mentioned, those dynamics. So, is there sort of an ego battle also between parties? Do you come across that? Do you have to?
Lots, according to me. Huh? I'm sure Lalit and Akanksha also have had their fair share of this. Okay. Especially a lot of the local Indian transactions can become extremely ego battles. Okay. And so I've been in a few of those where it no longer remains the transaction but the ego between the parties as to who's getting what. And then those are quite hard to kind of handle because they're not based on reasonable commercial basis, right? So it's more on I need this because my ego says this is what I need. I think there what I have at least found is letting some steam generally kind of makes a difference, because sometimes it becomes extremely stuffy and they're not this thing. Just being able to let off the steam either by giving them a break for a while, or kind of just saying something which I think is going to let off the steam, okay, a little bit, okay, or
Is
giving them a
informal
perspective.
communication also part of it? Like, maybe going out for some informal gatherings and parties, so to say. Does that actually practically form part of these negotiations?
Pardon, I have not done that, so maybe Lalit and Akanksha have a better sense. So I'm not a very social animal, so I don't have that. But typically, what I have found is that if you're able to give a perspective to them as to how small this ask is in the scheme of things, of what is
Yeah.
important to them, it's a lot more about just talking to them, understanding what is important for them, and then why this is not an important thing in the scheme of things, or why this is not an important thing for other side on the scheme of things, or why is it important for other side in the scheme of things. Kind of helps a little bit, but sometimes it's just steam off. I think they do their own things. Ultimately, Indian businessmen are very smart, so they all know that the value falls in time, so they always come back on the table, and we're able to well. And sometimes the deals just don't happen. I mean, it's a reality of life. I have seen cases where there's been ego battle between people, and it's just the deal has not just happened. So I think all sorts of examples. So that's something which I think, and these are not things that you can explain. Only when you are in a real situation, you'll understand what we're really trying to say.
Well, thank you so much, Patri. I'd like to welcome Akanksha's thoughts on this. Akansha, like Badri mentioned, what has been your experience on dealing with some of these high-headedness or, amongst parties or ego battles between parties? And before I go to my next question, I would like to know your thoughts on this.
I mean, it's a lot also driven by the rapport that you have with your client. So one thing, of course, is that the rapport that reaching out to the other side and speaking with them, but also to understand where your client is coming from. And yes, some of it may not be rational, some of it may not make commercial sense, but you need to understand why they are insisting upon a certain thing. And I mean, I would also like to caution that sometimes your clients also not always all that honest with you. So you need to be able to figure out whether they really care about it or whether they just are throwing their weight around, because that happens as well. Because sometimes, I mean, although Lalit has mentioned that negotiating with lawyers is very hard, and you spend the most amount, I guess, of the brain cells just trying to negotiate with the other side lawyers. But that's really not because we don't want to agree on things. It's just that we don't have the authority to agree on a lot of these things, and it becomes easier because we can gauge what our clients are okay with when we do that. So oftentimes, sometimes it's just trying to communicate with your client, trying to communicate with the other lawyer to set the message across that we want to do the deal. Don't get frazzled, don't get worried about it. We want to go ahead with it. Give us some time. Let us try and figure out a solution. And sometimes some of these things are so petty that you can get over it by agreeing to something which is sort of a compromise, and get both parties okay with it. But yes, it's a bit of being a psychologist also, not just a plain hard-headed lawyer looking at a document, to try and understand your client, understand the other side lawyer, understand the other side client as well. So,
I think that's a great point. Psychology plays quite a part in these days. And, My next question to you, Kanksha, is when you're looking at the letter of intent, an agreement, or a contract, how do you differentiate between these, and what are your thoughts behind approaching each of these documents?
So the first thing you want to understand is how far do you want this to bind your client and the other side. Because when you're looking at a letter of intent, and I think there was a judgment recently which says the letter of intent is also binding based on the terms of the contract. So I need to first figure out that whether the letter of intent is intended to be binding and to what extent, because there may be some clauses which are more legal in nature, such as confidentiality, etc., which you would in any case want to bind both clients. And there are some which are commercial where you want to just have some kind of idea of where we're going. But it may not be it may not be completely sacrosanct, and there will be negotiations in relation to all of these things. So the letter of intent, I would like to look at from the perspective of, for number one, what needs to be binding, whatever is not binding, and whatever is commercial. That is going to form the basis of your definitive documents. So whatever is supposed to be binding is based on the commercial that are espoused there. So what are the letters, right? So the letter of intent will generally say, I agree to buy XYZ from you for rupees 100 crores, but I need to do diligence. I need to see your results in this time. So there are a lot of conditionalities that are added to that. So I need to then see what are these conditions that could affect that price. So that is the way I would look at a letter of intent as to, okay, fine, this is the broad intention for this transaction. And what are the things that I need to look for when I'm trying to finally negotiate the price. When you're looking at a definitive document, you're going through it with a fine tooth comb. You are looking at every single word and seeing what the implications of that are. And you also look at the letter of intent because that forms the basis of interpreting what the intention of the document is, right? So, as we spoke last time, if a contract is uncertain, I don't have to, I mean, if the contract is explicit, I don't need to look at anything else. But if a contract is uncertain, I could possibly look at surrounding circumstances, and letter of intent possibly could have given me some idea. So, as an example, if there is a clause saying that the company needs to maintain its profitability, of a certain level, and on that basis, there will be a certain additional amount paid out, which we tend to call an earn out, right? But the parameters have not been very clearly set out. I may look at the LOI to see, what are the parameters of profitability that were, evaluated by the parties at the time of the LOI, and that could provide the context to my interpretation of that clause in the definitive document. So, yes, you look at everything at the fine tooth comb, but yeah, the provisions of the LOI also could help you understand what the parties are really intending.
Thank you, Akansha. So that tells us that all these documents are important, and thought process matters. We initially discussed, in the beginning, the question of illegality in a contract and maybe the ambiguity of it. Now, a related question that would you then suggest, putting, anti-corruption or anti-money laundering clauses in your contract, and how do you actually go about negotiating these? Because there is absence of law in certain jurisdictions when it comes to anti-corruption laws. So how detailed are laws across all jurisdictions, and how do you actually go about putting them into your contracts?
So here it's very dependent on the parties that you're dealing with, right? So if you have a client that is a multinational that has foreign investment, they are required to comply with certain norms which are not applicable in India. Because otherwise their foreign parents or foreign shareholders will be exposed to very large liabilities, in other jurisdictions. So you need to be mindful of the fact that yes, there is an Indian company called Business World India, but Business World India's parent is an American company. I mean, for sake of an example. So although Business World India may have, is only subject to the Prevention of Corruption Act, which is more limited in scope than the, FCPA, which is the American anti-corruption law. if Business World India does anything which is wrong, that would cause a lot of loss and liability to its parent in the US. So you need to look at it, because many times when you're dealing with Indian clients who are entering into contracts with non-residents, they get a bit worried when they see these clauses, because they're saying, why should we be looking at these things at all? I am an Indian. This is not the law of India. I should not be bothered about it. But it is something about something that would seriously affect the other side. So that is one part. The other thing that you didn't mention is sanctions, right? So there are UN sanctions against certain countries, and the US, etc., also have these type of liabilities attached if US companies or their associates, affiliates across the world are entering into contracts or dealings with sanctioned entities. So you need to be a bit, I guess, understanding of this is the way I would look at it. And also some of the things that I found helpful is to make my Indian client understand that this is good for you, right? It is good for you to have this kind of compliance regime in place. Don't look at it more from a positive angle, but yes, there is always a give and take as to what is the extent of the obligations that you look at. So to some extent, some amount of practical give and take needs to be done, but from a concept perspective, I would not really fight against it so much. And if my client is uncomfortable with it, I would still try and get them to agree, because I believe it is a reasonable ask from the other side. And and it is good for us to mind our compliances as well.
Thank you so much, Akansha. I would request the other panelists to join us on the floor so I can have a common question put out to all the experts. I will now go around the floor and require you to share, your experiences of a tough negotiation and how do you manage a deadlock. And also, if I may add to it, a multi-pronged question on a very popular document. We received a lot of questions on it. Is how do you go about drafting or negotiating a non-disclosure agreement? A lot of the time, businesses are afraid to share their ideas, and when walking into an investment or fundraising arrangement, I think NDAs form a very important part of those kind of negotiations. So if you could add all of this to your experiences and share your thoughts, starting with Mr. Kumar, please.
Sure. So your question on deadlock, Ashima. See, deadlock is a difficult situation. Definitely. I'm assuming you meant by deadlock when we are negotiating and we couldn't reach consensus, because there's another deadlock where you have executed the agreement and on a certain decision, both parties are not able to arrive at consensus. But that is during the term when the agreement is already signed and it's in operation. Now, deadlocks do happen. I think on very, very high level points, there would be very few, 2 or 3 principal level points where the parties are not able to take any decision because none of them can budge from it, move behind. I think those are never resolved in isolation, is my experience, that lawyers will never be able to get consensus on that. So both sets of parties, the contracting parties, come together, really discuss things through. And if the objective and intention is to close a transaction, I think they will budge something, they'll find solution. And many a time solution is found. Someone moves the distance and someone, backs off and things move on, or one gives something in return of other thing. But if unfortunately, if nothing is coming out, I mean, it's loggerhead, then unfortunately the deals do get closed. But I think people do come and discuss a lot, and in my experience they do come to a common ground. But again, I would say there is no real hard and fast way one can say this is the way you can resolve a deadlock. But I would say one has to maintain the cool and calm, because over aggression and showing that I am right and the other is wrong doesn't work. You have to be very, very receptive, very cool and calm about things. And I have seen people do tend to agree to you when your arguments are convincing. When your arguments are, as they say, in our negotiation, never raise the, your voice, but raise the level of your argument. So once people argue well, explain their viewpoint well, convince the other side, I think the chances are people will reach common ground. If not, then unfortunately, deal will be called off.
Yeah. Thank you, Mr. Kumar. And any ideas on your negotiate when it comes to negotiating NDAs or drafting them?
See, NDA is quite sticky because this is the document pursuant to which you will get, if you are a recipient, everything which is very confidential, and the person who is sharing confidential information is very apprehensive that I would be sharing everything. What happens if the deal doesn't go through? The other side has got to know everything about that. But yes, whatever apprehensions are there, but NDAs are required and NDAs are signed. So what I would say, they need to be very elaborate. And at the same time, if I am representing someone who's sharing the information, they should be inclusive and not exhaustive. What I mean by that, you should try and cover in the definition of confidential information that you are sharing, whether it is IP, whether it is your business plan, whether it is your business practices, financial information, every information that you share with the other party during the negotiation, make it more exclusive, beg your pardon, inclusive than exhaustive, because it should get a very wider interpretation. So much so that I generally try to even say, mostly I do not succeed, but I do try and say confidential information which is given in writing or in oral, or later on reduced in writing. But of course, sometimes I get this clause, sometimes I do not. Then have a strong and very stringent clause on breach, which means that if the other side who's received it breaches it, there are stringent penalties and provisions with respect to that. And should the deal not go through, still the confidentiality provisions should not end with the termination of the contract. They should have a surviving provision of 1 or 2 years, or till the confidential information becomes public. So these are certain ways to write a good and a tight clause, sorry, not clause, but the agreement on confidentiality. And I think one should not get too much panic about writing such contract. They are required, and they should be accepted.
Thank you so much, Mr. Kumar. I think some great points there. Make the agreement as inclusive as possible, has stringent sanctions, and have surviving provisions. So thank you so much, Mr. Kumar. Mr. Narayan, your thoughts on the same?
No, I think Lalit has answered this really well, and I don't think I want to really add to that. These some of these NDAs are like really, really sticky, and I think, like I said, I think he's covered it really well.
Sure. And my first question was, your experience with some of the hard negotiations, and how did you find your way through it?
I think we all muddle our way through these things. I think there's no, I mean, at the end of it, at the end of it, you take credit for it. But I think during the negotiation, you're always, what I always feel that we are sometimes in control, and most of the time not in control, because there are too many people in it, and then you just muddle through it and hope that everybody comes together at the end. It's more like a Bollywood movie. It starts, and then there is a plot, and then it all comes together. Like I said, my own experience is that you try to get consensus. That's the key thing. And I think one of the things that I find sometimes is that I think as lawyers we tend to not give bad news to our clients. Okay, so we don't tell them that, boss, you're being unreasonable. Okay, we tend to be their lawyer, because I think we have a feeling that if we tell them that they're wrong, they will find that we are not going to be fighting for them. I think that many clients also project that if you're disagreeing with me, that means you are not my lawyer. So I think, but sometimes you have to have that. I mean, you should have the trust to the client. Okay, that once in a while you'll be able to come back and then do this. So yeah, those are the things that I would say on this.
Thank you so much, Patty. I think that's a very pertinent point to make, that one should be clear with their clients on where the deal is headed, and even if that comes with some bad news, that must be shared. So thank you so much for that tip. And Akanksha, over to you for your final word on how you approach your negotiations, and one key tip for our lawyers.
Okay, so the way I would look at it is, and this is also something I heard in a negotiation workshop that really kind of penetrated, was that you need to figure out what are interests, not positions. So what is it that you're trying to protect, right? It's, when you see a contract, you should be able to understand every single word in that contract, because many times people just want to put in everything hard. I want this because it's going to protect me. But what is it exactly protecting? Which is the interest it is protecting? And is that interest a real thing? So if you're able to understand why and what is the interest that is being protected, it's easy for you to explain it to the other side as well. Many times, if you don't really know what you're trying to protect, you're just, just saying, okay, no, I want this, but because it's important to me, because I want to protect it, this is going to protect me. But my question would be why, how, if I were on the other side. So my thing is, you need to understand what you're trying to protect, and what is the interest that is being protected, instead of just having a vague notion of, okay, this is going to protect me. So that is really something that I think makes a lot of sense, and also makes you a very convincing lawyer. And it's very hard then for the other side to say, oh, I won't give this to you. But I think this is a genuine issue that I have. This is something that I really want to do. This is the basis on which I'm willing to move ahead. So either you agree to what I'm saying or find me a solution, or I will find a solution for it. So this is a tip that I would definitely want to give out.
Thank you so much, Akanksha. I think that's an important tip to have, that one cannot be looking at the entire aspect of things as important. It's important actually to know which are the most valuable things to protect in a contract or a deal. We have a couple of interesting questions from the audiences. So before we close the floor, I would like to bring them on to anyone who would like to answer this. Any contract drafting book for beginners? Mr. Kumar, if you'd like to take the question.
Well, sure, but I would not know any by the name, but there are many books out there. Do check it out. I think there are international online websites also. You can go there, get to see how good contracts are drafted. Uh, I would not know any specific book, but yes, it's good to read them. That what books, what these authors tell you. It's very good. I must just urge, of course, I am about to finish a very nice book by Lord Denning. I would say out of context. Plus, do read something which is called The Closing Chapter. This is not for beginners. This is for everyone. People who draft contracts. Lord Denning, in his book Closing Chapter, is trying to say, please be simple, crisp, and clear. Do not show. Your strength as a lawyer is not how complex legal documents and drafts and agreements you can draft, is how simple you can draft that they can be interpreted and read. So I would urge to read that at least. And of course, there are multiple books to learn about reading contracts and learning how to write them. But I would still say, please try your hands on them yourself. That will help you much better than just reading the stuff.
Thank you, Mr. Kumar, for that great recommendation. I think that would be a really great read for a lot of our audiences and lawyers and entrepreneurs. So once again, Closing Chapter by Lord Denning. I hope you get your copies. And but over to you, another interesting question is: are human rights clauses being included in contracts? Is this a trend, or would you also recommend this?
I have so not in the so I think a good question. Okay, I think it's not as prevalent except in some cross-border contracts. Especially now, you have to give declarations with respect to child labor, bonded workers, and certain practices that are there with respect to workspace. But I think that's and I think some of the bigger companies, okay, with ESG and more importance of ESG, which is environment, social, and governance. I think that's what it holds for ESG. I think that's becoming important. So we are seeing some of those ESG clauses which are being inserted now, especially when you're getting money from sovereign funds and so on and so forth. But explicit human rights, I know that when I speak to some of my colleagues in other countries, especially for some of the other countries which procure, say, for example, from Africa or from other countries, they're having a lot more provisions with respect to these aspects, because there's a perception that companies can do something about this, and to be more responsible when it comes to procuring, especially raw materials on things. But I have done a few, but not too many. I think in India, we're still not got to that stage where it is. It's typically more of an employment kind of an issue. I'm happy for others to kind of comment on this.
Yeah, thank you so much, Patri. Mr. Kumar, I will take this up with you first and then over to Akanksha. That are you seeing human rights clauses being entered? Because there is always brands get crushed over whom they're finally employing for their fashion and retail merchandise, and that's been in the news all the time. So now, is there a way to protect that in your contract? Are you seeing an increasing trend in that?
Yes, slowly and gradually, especially see in contracts relating to, say, contract laborers. For example, people who work, you have a contract and large workforce comes to you to work. And then there are clauses with respect to how you would treat those people. And, you have to, all those clauses do come in employment contracts, in consulting contracts, employment contracts. So wherever manpower is involved, these kinds of clauses are part of the contract, but yes, they are now evolving. Not that we had seen them, and as voice for human rights and other related issues are rising, and people are getting conscious, and they wanted to be part of contracts. Yes, they do come, but I agree with Badri. Still, they are evolving. It's not that they are very, very prevalent, and you find everywhere, and heavy negotiations are happening around them. There are good standard clauses, but they are still restricted to agreements which are related to manpower, employee, and human resources.
Thank you so much, Mr. Kumar. Mr. Joshi, over to you. What are your thoughts on having these sort of clauses in a contract? And, could this be part of a brand building of an organization to make them come across more conscientious in their efforts? What would be your advice?
So I'll take this in two parts. So, I mean, you don't see it in every single contract, but you're seeing it more and more. And you're seeing it in contracts where the counterparty is, an institution, a foreign institution such as a pension fund, etc. Because they have certain investment objectives. So they are not purely, I would say, commercial creatures. They also have certain social functions so social purposes and social functions. So, which is why you would see this more in, an investment by such entities rather than otherwise. But yes, I feel at least in the last maybe 6 months or so, there's a huge, popularization of ESG in India. So, although I'm not seeing it in domestic transactions today, because of the requirements of large listed companies to comply with their ESG requirements, I do see that it would start making sense for even large corporates in India to adopt those kinds of measures and put in clauses to require their counterparties also to comply with it. Brand building, of course, it's nice to say I'm net zero and I am not employing child labor, etc. And to have those contractual comforts, but I think it's also more I think of a social aspect to it, and also to comply with the corporate governance and ESG norms that various regulators are now setting on us.
Thank you so much, Kamsha. And with that, thank you so much to our panelists for this absolutely intellectually nourishing and stimulating conversation. I hope our audiences got as many tips, from you all. And thank you so much for joining us again this Saturday and continuing with the part 2 of the discussion. So grateful for your time and looking forward to continuing these conversations with you. Thank you so much, panelists, for joining us today.
Thank you.
Thank you so much.
Thank you.
Thank you.